Us live. And almost there, almost there. And waiting. We multicast. We live cast on YouTube, Facebook, and Periscope. We're waiting to get approved on LinkedIn. But it looks like we're live now on YouTube as well. So hello and welcome, everybody. My name is Robert Gruler. I am a criminal defense lawyer in Scottsdale, Arizona. My team and I, we've represented literally thousands of people facing criminal charges. We spend our entire lives in the criminal justice system. And when you spend that much time in the system, you get to see where the problems are. You start to see these patterns develop. And what we want to do with this show is highlight what those patterns are, highlight where the misconduct is seen, where the problems are, so that we can really encourage meaningful reform. So that's what we do on this show. Every week, we go through the news, we talk about some of the problems that we see, we highlight these things so that we can shine some light on them. Because unfortunately, what we have right now is too many really bad guys masquerading as good guys, and they're doing it hiding behind a gun and a badge. And we're seeing the results of some of this malfeasance and this misconduct in the protests and in the riots that are happening all over the United States and all across the world. Of course, those were kind of a long time coming. You know, this is something that I have been sort of predicting for a long time. I've called for this on this channel, that what happens if people decide that they don't want to participate in the criminal justice system anymore? What happens if they just think that this whole thing is unfair and they want to dip out of it? Well, we're seeing a little bit of that. We're seeing, you know, these different groups set up these autonomous zones. We see these different organizations sort of formulating and starting to pick sides and declare some of the things that they want. And it all stemmed from bad police, bad popo, as we call them here on this channel. These all started with misconduct from bad officers who were essentially murdering people. And so today we've got some updates. We've got some updates that I want to share with you on a couple of different stories, of course, that we have been covering on a regular basis. One, of course, we're going to start with is George Floyd. Quick update on that. We have some video from the police union that came out, and I want to share that with you. We've got updates on Breonna Taylor. We've got updates on Rayshard Brooks, and we have updates on Ahmaud Arbery. Some interesting developments, actually, and we're going to hear from, believe it or not, Beyonce just made the show. So she is included in my slides. She sent a letter. I want to show you a little bit about what that looks like. And we've just got a lot in store. Now, for the second half of the show, once we get through the headlines and the updates, I want to dive into the General Flynn case. General Flynn, this case has been going on for years, and I really haven't done a deep dive into that on this channel. The reason being is because it's just been really fast moving, and it didn't look like it was coming to a conclusion anytime soon. Well, we're kind of at that point. There was a ruling today from the Court of Appeals out of the D.C. Circuit that is ordering the lower court, the district court, to actually dismiss General Flynn's case. I have a copy of that opinion and the order from the D.C. Circuit. We're going to talk about that as well. I have notes. I'm going to run you through what the order looks like. We'll kind of dissect it here and there just so you have an understanding of what it looks like. Because, of course, when we're talking about General Flynn, we're talking about the Trump administration. And, of course, anytime the Trump administration comes into play, there's going to be highly politicized people on both sides of the conversation. Everybody's going to be very aggressive, saying whether or not, whether this is proper or improper is kind of a matter of national security. It's a matter of national, wherewithal. What are we doing here? What is our justice system look like if this type of stuff is going on? And depending on what side you're on, you're either very happy with the dismissal or you're very upset about it. And so we're going to dissect what the arguments were, why the D.C. Circuit Court of Appeals ruled the way they did. I read the opinion, didn't spend a lot of time on the dissent, but we're going to dive into that on the second part of this program. So let's dive into it today. I want to talk about some of the updates as I was mentioning. And one of the first ones comes from the George Floyd case. So not a whole lot of real kind of significant developments in terms of any legal action. We're still seeing kind of a slow roll. They were all charged. We're waiting on court dates and trying to figure out what's going on the back end there. But we are getting some more communication from some of the other police officers. So there was a video I want to share with you. It comes from CBS, and they have some of the police officers unions from Minneapolis actually come on her show, and she asks him a question. Basically, are you ready to go ahead and condemn what you saw on the video? I mean, can you address, your position on that? You're the union. You represent huge swaths of police officers from Minneapolis. Maybe now is the right time for you to come out and actually make an opinion and tell us what your position on this is. And of course, we're going to get, kind of the same deflection that we hear from a lot of officers around the country. And in this case, well, I'll let you hear for yourself what they say.
Are you all saying to us that you can't really make a comment about this case until you see every piece of video associated with it? Is that what you're saying today?
We would just like to see what we are entitled to in our agreement, in our policy, is our officers' body camera footage. It may shed some light that we're unaware of. Right now, we cannot make an informed decision regarding the other officers that do not appear on camera.
Okay. Can you understand?
Yeah. So, they go on and they say, she asks him back, you understand like how hurtful that is, right? You understand that the rest of the country and the world, we saw the video pretty clearly. There's not much more that we need to dive into in order to come to a proper conclusion. You understand that the fact that you can't come to a conclusion, that's concerning, right? And he goes on and says, yeah, we know how serious this is and we know it is a problem. But basically his point is we can't comment on what the other officers did until we start seeing some body camera footage and whatnot. I mean, at this point, it's baffling to you and me. I don't understand how somebody could watch that video and hear all those people shouting at George Floyd, shouting at the officer. He's screaming for his mother as he's dying. All of this is going on back and forth. And the union and the representatives for the law enforcement agencies, they still are coming out and saying, well, yes, but we don't have all of the information yet. We know it was really bad, but we can't talk about certain aspects of these cases because of these policies that exist. Well, to me, this kind of highlights some pretty big problems with all of this stuff. If they're going to continue to hide behind the policies, then the policies have to change. I don't understand why that's not happening. Why have these guys, the police union, why have they not seen the body cameras? I have not seen any body cameras from George Floyd's case. I don't know what happened other than what we've seen from the surveillance footage and from the civilian recorded cell phone cameras that you and I all saw, the whole world saw those videos. We haven't seen anything else from the inside of the law enforcement department. Apparently, none of the union representatives did either. So what is going on? If they can't even comment on these things, why are they not getting access? Why can they not see these things? How can we expect them to police their own officers if there's no transparency there? This type of stuff just illustrates, it magnifies where some of the problems are. You've got, one union. In other words, all they're doing is they're pointing fingers at each other. This is what happens with law enforcement and with government in general. Everybody just points their fingers at the culprit who, they don't want the liability, the responsibility for it. So they just point at the other agencies and say, well, because of their policies, we can't do anything. We see this all the time in criminal law. Everywhere we go, we see it. We see it with prosecutors. We see it with police. We see it with judges. They all have their own policies. And what they do is they deflect their actual job responsibilities. They dump it back onto the policy. So let's say, for example, you are a criminal defense attorney like myself. You go into court. You want to speak with the prosecutor and talk about resolving your case. You've got a great client. They have, a situation, a case, criminal charges. You want to propose a resolution to the prosecutor. You would think that you could just have a simple conversation with them. Well, unfortunately, that doesn't happen too much because what they're going to do is they're going to say, I really agree with you on that one. I don't think that this guy should be convicted of that. Kind of ridiculous. But I can't do anything about it because that's our policy. So they all defer to the policy. My boss won't let me. Our policy says this. And this goes on and on and on. And you can see it in that clip. Again, law enforcement is deferring to their stupid policies that they help create, that they enforce. Don't tell me that the union and these law enforcement organizations don't have a say in what the departmental policies are. We know that for a fact. We had that here in Arizona where the Phoenix Police Department, one of the biggest police departments in one of the biggest counties in the country, they have $1 billion budget. They organized when they, I'm getting flamboyant here, I'm getting angry. They were getting their contract. So the way it works is the police union, they have this big group of police officers who are, working in unison as a union. They're organizing in a union, so they have greater bargaining power. They're called PLE, the Phoenix Law Enforcement Association. It's a police officers union and organization, all that stuff. What they do is they negotiate a contract with the city. So the city then comes in and says, we need law enforcement. You have all these officers. Let's come to an agreement. Let's sign a contract where we're going to pay you this money. You're going to disperse it to your officers. The officers are going to patrol and police our streets. And in exchange for that, we all keep our jobs. We keep our city safe. We get what we want out of it. Well, what happens is in that contract, they negotiate for certain things. So they say, as was the case here, that they could not keep their personnel files, their disciplinary records, any records of malfeasance past a certain period of time. If I remember correctly, it was 5 years. So the union put in their contract that you got to wipe the slate clean of our officers 5 years after they've committed some sort of malfeasance. So the unions and these law enforcement organizations are creating their own policies that they're then sort of pointing their fingers at and saying, oh, no, that's a government policy. We can't do anything about that. And you saw that in that last clip. So these guys, they never want to accept any responsibility. They want to do as much as they can to deflect the question away from them. The guy could have come out and just gave a flat out comment, but he's beholden to all of his underlying officers who are all going to be furious if he does go out and say that. He's got to be in alignment with his troops. He's a general of the law enforcement troops, and he's got to be the one in front and center on CBS Good Morning and saying, I can't comment because I haven't seen anything. The rest of the whole world has seen it. We can all comment on it. The fact that this guy can't, I don't know what I don't know what he is missing. I can see it pretty clearly. You can see it pretty clearly, but he can't come out and actually come to a logical conclusion. Kind of embarrassing, but those types of things are the things that I think illustrate some of the major problems in our criminal justice system. It's no accountability, no responsibility, protecting other officers from their own malfeasance, refusing to call a spade a spade. We got to just clear this stuff up. If an officer's a bad cop, he's a bad cop. He's got to go. Why we keep just creating these policies and pointing fingers at one another, I have no idea. I have no idea why they do that. I know why they do it politically. I knew why they do it for their officers, but in terms of your personal satisfaction, your integrity, going to sleep every night and saying, I'm really proud of what I'm doing out there, I can't fathom how they do that. They can't even call a spade, and it's a bummer. So that's the update on George Floyd. The next update that we have for you is about Ahmaud Arbery. Some good developments in this. Actually, we've got some breaking news on this today. So a grand jury has officially indicted all three of them. We've got indictments that came across the board today for Travis McMichael, Greg McMichael, and William Roddy Bryan. They got malice and felony murder charges. And so that's good news. They were arrested and they were prosecuted. I think they filed a direct complaint, and that has since gone over to a grand jury, and the grand jury officially indicted them as of today. And so they've been formally charged with malice murder, 4 counts of felony murder, 2 counts of aggravated assault, false imprisonment, and criminal attempt to commit false imprisonment. So, of course, that's something I've been advocating for here. One of the most controversial Watching the Watchers episodes that I did was on Ahmaud Arbery, and people were all, we're all kind of upset on both sides. Some said it was justified, some said totally unjustified. We did a very deep dive analysis on the letter of the law. We looked at all of the statutes. We said that there was no citizen's arrest that was even feasible under the law and under these facts, and therefore they should all have been arrested and charged and indicted. And they were. So that is good news. We do not want roving bands of, ex-law enforcement people chasing people down through the neighborhoods and then shooting them. That is not the America that I want to live in. I presume it's not the one that you want to live in. And it's not it's not what the people of Georgia wanted to live in, because when they heard the facts, they indicted these guys. So here we have another breakdown of it. Gregory McMichael charged with felony murder. Travis McMichael charged with felony murder. William Roddy Bryan. This was the one I was a little bit, questioning. William Roddy, if you don't remember, this was the guy. So Travis and Gregory, they hopped in their car. They chased Ahmaud as he was running down the street. They, did a U-turn and they blocked him. William Roddy was the one who was the neighbor who arguably wasn't as involved as the other two, but once you sort of saw what happened there, he actually blocked his car, which I think leads to the false imprisonment charge, illegally using a vehicle to confine and detain Ahmaud. And so evidence was found that Arbery was boxed in by both McMichael's and Bryant's pickup trucks. Georgia Bureau of Investigation, the agent testified that the gunman, Gregory McMichael, said a racial slur as Arbery was dying, which is news to me. That was something that that I had not seen up until this point. Some specifics, actually. It says the shooter, McMichael, allegedly uttered the words effing N-word as he was dying on the ground. They fate, which is, without words, you can't even, as you shot somebody in the chest who you chased down, you utter another swear word there. So, fortunately, Georgia approved a hate crime bill. We'll get there on the next slide. But first, the defendants face a minimum of life in prison. So George, Travis, and William, they're all charged with felony murder, which means they're all facing murder charges. Felony murder is a kind of a special category of murder. If you're involved in a felony and somebody dies in the commission of the felony, you get charged with murder for that. So even though Travis was the one who actually pulled the trigger, Gregory was also charged with murder, and William Roddy Bryan was also charged with murder. So that's how that works. Special prosecutor Jesse Evans said that Arbery was chased, hunted down, and ultimately executed. And I agree with that. The position here has been pretty consistent on it. I went through the statutes, went through the facts, everything else that everybody was coming up with in terms of their arguments, I think, has pretty much been debunked at this point. All of the prosecutors now who are involved decided that charges should be filed, and they've been indicted, and they're moving forward with the charges. If you remember from our previous show, it took them months, like 2 months, before they even filed this thing. It got kicked around between 2 and then 3 prosecutors, and it was not something that they wanted to do. If this video had not leaked, if that guy and that defense attorney had not leaked the video of the Ahmaud Arbery shooting, I think this whole thing would have been whitewashed. We would have never seen anything about it. It would have never made the news. But the video is what brought it to light, and I hope there's some more repercussions. I hope there's more repercussions, not just for Gregory, Travis, and William, the people who killed Ahmaud, but the prosecutors who tried to whitewash this case. The fact that they are still employed and prosecuting and they're not being investigated, maybe they are, maybe their superiors are doing something about it, maybe the state bar is doing something about it, but these guys had the same evidence that you and I have. They had the same evidence that Special Prosecutor Jesse Evans has. They had all of the same evidence that the grand jury saw, and the grand jury just indicted them on all of that stuff. So how is it that 2 or 3 prosecutors sat on this thing for months, and it wasn't until their hand was forced that they decided to take some action? How did they get away with that? I think it's the blue line. I think it's the blue shield. As you recall, one of the McMichaels used to work there, used to work for this county as an investigator and as an officer. So when he was involved, he got the benefit of the doubt. They tried to protect him. They lined up. They circled the wagons. They implemented the blue shield, and he didn't get prosecuted. Not until the video leaked out did anything substantive happen, which is a damn shame. But stuff is happening now. Those guys are all being charged with murder. They're probably going to get convicted. I don't see any way for them to really get out of it. Who knows what they'll negotiate? Who knows what kind of nonsense backroom deals they'll try to negotiate with that corrupt prosecutor's office out of that county. But we are going to continue to monitor it, as I promise on every show. We're going to follow these stories around. There are going to be periods of time when there's nothing going on and we're not going to have anything to comment on. But for the time being, these guys have been indicted, which is good news. Now, Georgia also passed a hate crime bill, which allows enhanced criminal penalties for people who target others because of their race, gender, orientation, which is sexual orientation or other reasons. Georgia was one of 4 states without a hate crime law. Now judges imposing sentences can increase punishment against those who target victims based on race, color, religion, national origin, sex, sexual orientation, mental disability, physical disability. So now there is hate crime legislation on the books in Georgia. Now, I haven't read the official statute or see what it looks like. I tend to have an issue with laws that can be applied sort of arbitrarily, and something like this is very difficult to prove. It's difficult to prove whether or not somebody is acting on a racist basis. Now, you can presume it. You can come to a lot of conclusions. The fact that one of the McMichaels, said effing N-word as Ahmaud was laying on the ground dying, that's a pretty good indicator to me that this was something that had a racial component to it. So when you have facts like that, it's pretty clear. But if we did not have facts like that, so let's take that little key nugget out of there, how do you determine that this is a racial thing or not? I thought it was my perspective on this thing was it was a bad police officer, lunatic, roving civilian psychotics going out there and trying to be, little dictators in their own neighborhood. It was a police problem, not necessarily a racial problem. And all of the racial talk was just fanning the flames of racial tension when really this was a police problem and a prosecutor problem and a judge problem. But then it transformed into this racial problem. So I understand that there's racial issues throughout the country. There's no question about that. But the issue is what happens to defendants, people charged with crimes, when suddenly everything becomes a hate crime? What if the victim of a crime just happens to be black or gay or whatever's going on, transgendered or, physical disabilities or from a different country or any of those things? It's really broad. Race, color, national origin, religion, physical disability. I mean, now we've got a whole, this opens up a huge can of worms. We've got a whole other set of laws and defenses. And now we have to argue whether or not we can prove that or disprove that, or somebody, hit somebody in the face and they're going to say, it's because I'm a Jew. I'm Jewish and he hit me in the face. I'm a Jew. This is a hate crime. Well, no, you were just being a jerk and you got hit in the face because you're being a jerk. But now everything has that additional component. Everybody's going to want to claim hate crime status. It's going to complicate the criminal legal world that much further. And what I think is going to probably end up happening is this is going to backfire. This is going to be something that is used against more people. Most of the people who are going through the criminal justice system who are in prison and in jails are disproportionately minorities. So if you've got that, going on, and now you've got these additional sentencing enhancements where you can give them an additional couple years or 4 years or increased penalties at the time of sentencing, this becomes, just another thing to punish people for. There are certain situations, obviously, where the sentence should be aggravated, which we already have laws on the book for that. We've got a presumptive sentence. We've got what's called a mitigated sentence, which is lower. We've got a minimum sentence, which is lower. We've got a maximum sentence, which is higher. We've got an aggravated sentence, which is higher. So you can include those things in the judge's determination on sentencing, but by just creating whole new bodies of law that we don't really know what the unintended consequences are going to be, and now this opens the door for everything, and every single victim of every crime now becomes the victim of a hate crime. And now we have to prove or disprove that in addition to the underlying offense. So in Arbery's case, not only do you have to prove that they chased down and hunted this guy and that there was no citizen's arrest statute and it wasn't self-defense and all of these other things, but now they got to go show that this also wasn't a hate crime. So it's just a whole different thing. In addition to proving those underlying elements, they got to prove something else. Now in that case, sounds to me pretty justified. If he did say those things, which is what the Georgia version of the FBI found, that's cause for aggravating his sentence. He acted with malice. He wanted to kill him, and he did so in part because he was a black guy. That's malice. That requires some aggravation, certainly. But does it justify having a whole new set of hate crime laws? We'll see. I think we're going to see more of these, but we don't really know how they're going to be implemented and what the repercussions are going to be. From my perspective, it's going to be more fuel, more tools to oppress more people who are going through the criminal justice system. Some of them are going to deserve it, no doubt. But what happens when this is unequally applied or applied with bias against the very people that the law was intended to help? So we're going to look into that. We're going to follow along. Arizona doesn't have anything like that thus far, but I know a lot of other countries do. And, this also brings up some pretty interesting constitutional, issues. We talk about hate crimes and we talk about hate speech. They're getting close to one another. A hate crime and a hate speech, which many of it, now we're talking about First Amendment issues, Constitution issues. I mean, this stuff gets messy very quickly. So we're going to see. We'll see what happens in Georgia. We'll see how the prosecutors use this. We'll see how it is being, disseminated across all of the different courts and prosecutors' offices and courtrooms, and how the judges respond to it and how they use it. And then we'll be able to see. But I'm all for solutions. This looks like a solution. This looks like it's moving the ball in the right direction because we're talking about these issues. And so that's the update on Ahmaud Arbery. We've got some good news there. Those guys were indicted, and it looks like Georgia is moving the ball forward. So good stuff on that. Okay, the next update that we have, this one, we have not spoken about it in some time. Now, I talked about a case many, many months ago before the protest. I think it was even before coronavirus broke out, but we were talking about a gal, Breonna Taylor. Covered her on this show, explained what had happened here. For some reason, this story didn't catch the same way that the other stories did, probably because there was no video of what happened. But the story is horrendous. What happened was Breonna was a very young 24, 25-year-old, young EMT. She was working in the healthcare industry, no criminal record, upstanding, beautiful, woman who is just doing everything right in life, doing very well. She's at home with her in her apartment with her boyfriend. SWAT team busts in, and one of the officers there just starts shooting, fires 10 bullets into into Breonna's room where she is sound asleep, hits her a number of times, kills her instantly. Her boyfriend fires back at the cops. He gets arrested. He's charged with attempted murder because he's firing back at the cops who did like a no-knock warrant. They just kick his door in, and they think they own the place. Because he's defending himself, of course, he's trying to kill the cops. And because we killed his girlfriend, we're going to charge him with a crime and arrest him, and we're going to prosecute him for attempted murder of officers, even though they broke into his apartment. So that all happened. She's killed. I covered the story, didn't catch any news. There was no video footage, unlike Ahmaud's case or Rayshard Brooks' case or George Floyd's case. There's when you can see the video, it lights people up and it causes a response. This case is arguably more gruesome because she got shot 10 times by this officer. And again, nothing happened. So here's the background on this. Breonna Taylor was shot on March 13th, 2020. And then the officer just got fired yesterday. So that was March. So about three months and about 10 days went by, and this guy was on the force the entire time. And the guy's name who was fired is Brett Hankinson. So let's swap over here. Brett Hankinson is one of the officers who barged into Breonna Taylor's home. He's been fired. It's this guy right here. He has been eliminated off of the department, and that happened effective June 23rd. So the reason being, he violated the department rules, procedures. He violated deadly force standards when Breonna was killed. He fired 10 rounds just blindly. No charges yet. Other officers, Jonathan Mattingly and Miles Cosgrove, have only been placed on administrative leave. So these two other officers were in sort of the roving band that broke into their home, and Officer Hankinson was the one who shot and killed Breonna, fired 10 rounds. We actually have a written letter from the Louisville Metro Police Department, from the office of the chief, over to the detective Brett Hankinson. And here's what it looks like. So he sent this over yesterday. Today's the 24th, and it's about the public integrity case. It says, "Dear Detective Hankinson, Please be advised, effective this date, your employment with the Louisville is terminated. Taking this action based on my review, initiated 13th. Your pre-termination meeting held today's date. The investigation conducted by their integrity unit. So again, they're investigating themselves. The following is the result of my subsequent review of the file. So 4 counts of violation of obedience to rules and regulations sustained. 10 counts of violations of standard operating procedure for the use of deadly force also sustained. So 14 counts from this one guy, all of them being sustained by the Louisville Metro Police Department. I have determined you violated SOP, obedience to rules. Your actions displayed an extreme indifference to the life and value, to value of human life when you wantonly and blindly fired 10 rounds into the apartment of Breonna Taylor on March 13th. These rounds created a substantial danger of death and serious injury to Breonna Taylor and 3 occupants of the apartment next to Ms. Taylor's. I make my determination pursuant to preponderance of the evidence. Also, the other 10 rounds, you blindly fired 10 rounds into her apartment without supporting facts that your deadly force was directed at a person against whom posed an immediate threat of danger or serious injury to yourself. In fact, the 10 rounds you fired were into a patio door and window, which were covered with material that completely prevented you from verifying any person as an immediate threat or, more importantly, any innocent persons present. So it sounds like these cops just, they were going in the back door. Sounds like the windows had some blinds or some coverings or something on there to block the light from coming in. This cop just goes in, fires 10 rounds. Presumably it was kind of on her back patio where she was sleeping, and the officer fired some rounds through there, hit her a bunch, hit her 8 times, 10 times, and killed her. And the chief, it's a scathing letter. It says basically there's no basis at all for what you did. In fact, you fired were into a patio door. They were covered, completely prevented you from verifying any person was a threat, or more importantly, any innocent persons were present. So again, this took about 3 months, just over 3 months, 3 months and a few days. This cop was somebody who, up until that point, sounds like he was being investigated, but had not been fired and had not been charged even. So the question then kind of becomes, well, what would have happened had the world not exploded with anger and rage against police officers? What if Breonna's case just kept going on the wayside and just gotten swept under the rug like many of these others? This guy still has not been charged with anything as of today. So a cop goes into somebody's house, she's sleeping, he fires 10 bullets into their house, kills somebody, and he hasn't been charged with a crime. The cops out of Rayshard Brooks' cases were charged. Cops in George Floyd's case were charged. Cops in Rayshard Brooks' case were charged. They all got charged, but not this guy. Not yet. We're going to see what happens. Letter goes on, and it says, This one was kind of shocking. We learned about this yesterday. Shocking that this is how it works. But here you go. This is directly from the chief's letter. So Robert Schroeder is the name of the chief. You can see his name down here, and he rounds out his letter by saying, "Hey, by the way, you have previously been disciplined for reckless conduct that injured an innocent person in Professional Standards Case 17062, which presumably means that happened 3 years ago." And you were disciplined for that on January 9th, 2019. So this guy just got disciplined last year in January for a case that looks like it happened in 2017. So the 2 years go by. This guy's on the force. You can see here. So just so you understand, this case is in 20. So the 19th public integrity case in the year 2020. So that means that if we take a look at the other numbers, he got a 17 case. So the complaint came across in 2017, and he got disciplined 2 years later. So he's on the force doing whatever he wanted to do for 2 years, and now he committed a new one, even though he just got disciplined for it a year ago. About 14 months before he shot and killed Breonna Taylor, he had just been disciplined for reckless conduct that injured an innocent person. And he hung on the force for a couple years while they did their investigation and their discipline, and they kept him on another one, and somebody died as a result of it. Breonna Taylor got shot and killed because this police department that knew that this guy was a problem kept him on. Kept him on. No problem at all. This is the problem, folks. This is what is so wrong with everything. They just sweep these things under the rug until one of these guys snaps. And again, what happens if the world had not melted down? Would maybe this one wouldn't have heard anything from this? Maybe now the chief of police is getting bombarded because people are furious. They know more about Breonna Taylor now, and now they're demanding some action. He goes on, he finishes it. These are extreme violations of our policies. I find your conduct a shock to the conscience. I am alarmed and stunned you use deadly force in this fashion. You have never been trained by the Louisville Metro Police Department to use deadly force in this fashion. Your actions have brought discredit upon yourself and the department. Your conduct, okay, on and on and on. I cannot tolerate this type of conduct. Your conduct demands your termination. I have the utmost confidence in my decision to terminate your employment, blah, 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 blah. So it comes three months later. This letter comes out 3 months later after George Floyd, after Ahmaud Arbery, after Rayshard Brooks, after statutes are coming down, after cities are being burned down. We've got this police chief who comes out and says, with gusto now, I mean, you read that. He's angry. Your actions have brought discredit upon me. Your conduct is severely damaged. Very angry, very upset. And just a litany of how upset he is. But he wasn't upset before. He wasn't upset in March or April or May. We just got it in June. And this guy had previously been disciplined. Was he upset in 2017, 2018, or did he have to wait until 2019 for him to get disciplined for his reckless conduct endangering somebody else? And so this is what goes on and on. Now, look, credit to Robert Schroeder, the chief of police, for blasting and firing this guy and putting all of that in the paragraph. But come on, man, we can all see what you're doing there. Now you are just blasting this guy because you have to do that. You know that anything less than coming out with a really hard PR statement, this is a public relations statement. Is what this is. He's not writing this letter to the officer. He's technically writing the letter to the officer. It's addressed to the officer, but this letter is for you and it's for me and it's for us to talk about. And it's for most people to go, yeah, good job, Robert Schroeder, chief of police. Get rid of those bad guys. And it's good. We want the good cops to get rid of the bad cops. We want them all going away. But we also want justice and we don't want delays in justice. Remember, justice delayed is justice denied. I understand that they have to go through their internal process and they've got their investigations and all of that stuff. But this guy should have been booted from the force in 2017 after his first complaint, or reassigned to desk duty, or gone through some additional mental health screening or something, because the process is broken. You cannot have these lunatics on the force killing people and injuring people and put them right back out into the middle of our society. It's not good. That's how people get killed. So that officer's off the force. I mean, on my reading of that, if this chief of police is right, the question then becomes, is he going to recommend criminal charges? Is Robert Schroeder, who is a police department official who is charged with with running the entire department, he has a say in how things get charged. In most cases, technically prosecutors don't have to listen to them, but a prosecutor typically does. If a prosecutor talks to a detective or an investigator and they say, yeah, this case deserves to be charged, prosecutors will lean on that pretty heavily. They'll say, yeah, we agree with you. We're going to go ahead and charge this guy. So if Robert Schroeder went ahead and recommended that charges be filed, you would imagine that the prosecutor's office would run with that. So let's see. Let's see if he puts his money where his mouth is. He said that a lot of this seriously impedes our department's goal. We never trained you to use deadly force in that way. This is a big part. We never trained you to use force in that way. Never to use deadly force in this fashion, which means that he broke their protocol, means he's outside of the agency rules. Qualified immunity should no longer apply to him. He should be liable for this thing, and he should be charged with it. He just fired a gun blindly into somebody's house. There was no threats. There was no evidence that there was anybody with a weapon on the other side of that window. And had you or I done that, we would have been charged and arrested with murder in a heartbeat, immediately. But this guy didn't. This guy's still free, running around, looking for a job, maybe looking for a job at another police department. We'll see. I'm going to guess this guy get charged too. just because of the political climate that we're in. I'm going to guess that he gets indicted or arrested here pretty soon. But until that happens, he is a free man running around. Now, how do I know I'm right about this topic? Yes, that's right, folks, because even Beyonce wants justice on this case. Even Beyonce wants justice. And so she sent a letter over to the Office of the Attorney General, to Daniel Cameron. This letter was dated on June 14th. So the great and powerful, the one and only Beyonce is also chiming in on the Breonna Taylor case. Here is what she says. Your office has both the power and the responsibility to bring justice to Breonna, demonstrate the value of the woman's life, bring criminal charges against all 3 officers, commit to transparency in the investigation, and investigate the response to Breonna Taylor's murder, as well as the pervasive practices that result in the repeated deaths of unarmed Black citizens, which I think are 3 pretty dang good points. Pretty good. Bring criminal charges. We saw that. Now, I don't know about the other 2, but certainly the one who fired the gun, absolutely, he deserves murder charges because he fired his gun without any justification. He used deadly force outside of the police department's policies, and he killed somebody who was not a threat to him. That's murder. Boom, clear as day. Transparency in the investigation is another point from Beyonce, and she's 100% right. We do want to know what happened here. What was the investigation process like? Remember, Breonna Taylor's case happened in March. That was before George Floyd's case, significantly, and before Ahmaud Arbery's case and before Rayshard Brooks' case. It's being sort of carried along because people are furious about it, and rightfully so. I covered it on this show. An insane situation. They had already arrested the guy who they were looking for in a different thing. It's just baffling how dumb they were that resulted in this death. And I side with Beyonce. You know, I think she's dead right on this one. Dead right. So she also wants to investigate the LMPD's response, which I agree with. I would really like to know what happened here. Why did it take 3 months? Why is this letter just now coming out? You know, does it really take that long to determine what happened here? Does it really? I don't think so. And that's that. Rayshard Brooks is the next one that we want to talk about. We got an update on this. Rayshard Brooks' funeral was held in Atlanta at the historic Ebenezer Baptist Church. That happened yesterday on Tuesday, June 23rd. And, you know, if you, as a quick recap for Rayshard Brooks, this was the one that I covered last week. I think it was last week, sort of at length. We talked about, Rayshard was the guy who was stopped for DUI. He was investigated. He was compliant. He did all the field sobriety tests. He blew in the breathalyzer, all of those things. Had a very long criminal record. And he, when the officers were putting his hands behind his back, they arrested him, and he lost it. You know, he just kind of snapped, and he didn't want to go back to prison. I think he was on probation. So the situation would have been, if he was on probation and got an arrest for a new criminal charge, they would have booked him into custody. He would have been in violation of his probation, and they could have sent him back to jail or to prison, depending on what he had going on. So he did not want to be involved in that. Obviously, he's drunk. They just breath tested him, and he runs. He gets into an altercation. He runs away, has a taser in his hand, is kind of aiming the taser back a certain direction. Another officer pulls his gun, fires, shoots him twice in the back, kills him. He's dead on the ground right there. Covered it also. I think that Officer Rolfe actually ran up and kicked him when he was on the ground, bleeding out. Horrendous situation. Again, one of those things where it's like, did this have to go this way? No, it did not. Of course it did not. And what happened? Unlike many of the other ones, the officer was charged actually quickly, and that led to a lot of problems. So the prosecutor, Paul Howard, was the county attorney who's in charge of prosecuting this cop, does so, and then Atlanta just melts down. They after Rayshard was killed, they burned down the Wendy's and they started a riot. Rayshard Brooks died, I think, that same night. This prosecutor, Paul Howard, files charges, and then the police department say, yeah, we're not going to go to work anymore. We're just going to call out, hey, we all got the flu. Remember the blue flu? Cops calling out. They don't want to show up to work. oh, you're gonna come against us. You're gonna impugn the police department. Well, how about we just let crime overrun your streets? You know, we say that we swear an oath and we say that we're going to protect you no matter what and all these things. But as soon as one of our officers is under attack or under threat or facing charges, we're just going to bounce. We're not going to hang out anymore. We're going to take our toys and we're going to go home, and you guys are on your own. You get to play ball by yourself. So that's what happened in Atlanta, which led, of course, to more criticism against Paul Howard. Now, Paul Howard, I don't know much about the man. My understanding, he's also under investigation for a number of different things, for ethics violations and whatnot. So, you know, think what you will about this guy, but Paul Howard faces criticisms from lawmakers and the Atlanta Police Officers Union for his decision to charge Garrett Rolfe and Officer Devin Brosnan in the shooting of Brooks. Says that Howard was, you know, he says that he was just doing his job and that they had enough evidence to move forward and they're not going to wait for anybody, which I agree. I mean, we watched the video. I thought it was pretty clear. You can't shoot a drunk guy in the back when he's running away from you. He's not a threat anymore. You chase him. You call a helicopter. You call backup, but you don't fire 2 rounds in his back and just say, he deserved it because he had a taser, which was already discharged. There was no active canister on the end of that thing. So is it a deadly weapon? No. Should the cops have known that that was no longer a threatening weapon? Yeah, but they shot him anyway, or the one officer shot him anyway. Now, you know, we've got Paul Howard, I think, is probably a little bit in over his head. You know, he's coming out now and saying that he believes there should be a national law that every police officer, so on and so forth, or anybody in contact with civilians should be required to wear and operate a body camera and utilize dash cameras. So that was his statement in response to his decisions in the Rayshard Brooks case. Well, hello, they all did have body cameras on and dash cameras on, and they still shot and killed the guy. So what the hell is that going to do for anybody? Nothing. It's not going to do anything. These guys still operate with impunity. They still think that they're above the law. They know they're being recorded, but they don't care. Officer Rolfe knew he was being recorded. They do the field sobriety test in front of the car, in front of the dash camera, so it's all being recorded. They knew it's being recorded, the whole fight and everything. And he still decides to pull his gun and shoot the guy. I covered that at length last week. I don't need to get into it about them throwing a temper tantrum because they just got their butts whooped, 2 of them by one guy. And, you know, they decided to also throw a little temper tantrum and fire their gun. Unfortunately, it killed the guy. So good news is that they have been charged. We're going to follow along on that, but that's the update on Rayshard Brooks. All right, so we are now going to have to talk about General Flynn, General Michael Flynn. This has been a story that I have been watching and sort of half following for a while now. Just reading headlines, just talking about the news, and it's finally coming to fruition. So today we had new information. The actual Court of Appeals for the D.C. Circuit issued an order and an opinion about General Michael Flynn. And of course, the question on everybody's mind is, was General Michael Flynn framed? Was he framed? And we're going to start trying to dissect this case a little bit. Now, before we dive into Michael Flynn, you know, this was the case. This has been, many people don't really, I think, connect the two. But a lot of everything that basically our country has been living through for the last 3 years, and anytime you've heard the word, you know, Russian collusion or collusion, they were all talking about stuff that emanated from this case. So it started with Michael Flynn, and then it blossomed up, and they were trying to, you know, to start to indict people from the Trump administration. They were even trying to impeach President Trump over this whole situation. So this, you know, bubbled up from a small little phone call that we're going to talk about here in a minute, and it went all the way up. We had, you know, hearings in the House of Representatives. President Trump got impeached, went over to the Senate for the trial portion of it, and he got acquitted there. So he wasn't ultimately impeached or ultimately removed from office. He was impeached but not removed. And this is something that, you know, basically it all started here. It all started with Michael Flynn, and this thing started way back right after the election. And so what I want to do is I put together this nice little timeline on Michael Flynn and the whole case and where we're at and how it got so messy so quickly. And so we're going to do a little bit of a deep dive into this case. And we're going to go through the order from the D.C. Circuit. So I have that. I have it all noted up, and we're going to dive into it. But before we do that, before we start kind of answering these questions, was General Michael Flynn framed? Let me give you some background on this guy. It's one of the most impressive guys I have ever seen or ever read about. I think it's important context for you. Most people, they just view people as a name and a number, and there's a lot more to that. So you may have heard General Flynn's name in the media, and you may have opinions about the guy, but did you know all of this? He was one of 9 children. He grew up in Rhode Island. He was an athlete, led his football team, Division B state champion, ROTC program, earned a degree in management. He joined the Army, and he began his career for 33 years in the Army. So basically, as long as I've been alive, this guy was in the Army. I'm 34, by the way. And he had been in the Army for 33 years. He joined as a second lieutenant in military intelligence. After 3 years as intelligence chief, he returned stateside for top bureaucratic posts, and he served as Trump's national security advisor. He also worked in the Obama administration. Many people don't know that. But let me tell you a little bit more about Michael Flynn, because it's insane. Okay, here's this guy, Michael Flynn, General Michael Flynn, deployed as a platoon leader to Grenada in 1983, named the Chief of Joint War Plans to the American Invasion, Haiti, 1994, served as the Director of Intelligence for the Joint Task Force 180 in Afghanistan until 2002. He commanded the 111th Military Intelligence Brigade, was appointed Director of Intelligence for the Joint Special Operations Command in Iraq in 2004, became the Director of Intelligence for the United States Central Command and then the Joint Staff. 2009, he took command of U.S. forces in Afghanistan, so all of them. He became the Director of Defense of the Defense Intelligence Agency in 2012. He retired 33 years after his time in the military with the rank of Lieutenant General. In 2016, he co-authored the book, The Field to Fight, How to Combat Radical Islam. He served as Trump go-to man for national security issues, rewarded with the post of National Security Advisor in November 2016. So he has some of the military's top honors. A couple honors: Defense Superior Service Medal, the Bronze Star Medal, the Legion of Merit, graduate degrees in telecommunications, military arts sciences, national security, strategic studies, honorary doctorate of laws from the Institute of World Politics. And on top of all of that, this guy married his high school sweetheart, and he's got 2 sons who his brother Charlie is also a decorated Army officer. He pinned the General's Star on his brother during a ceremony in September 2011. So the guy is like Captain America of of Captain Americans. You know, I mean, the guy has done everything. He's been around this country. He's served this country for many, 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 many years. And this is why people have been so fired up over this case. You're like, wait a minute, what is happening to this guy? This guy who has served our country so loyally and so long, and he's been such a tremendous asset to the things that we want to accomplish in the world. And now he is a traitor? What? He's been colluding with the Russians? What? What are you talking about, right? Like, people just don't get it. How can somebody who has done all of these things just be a traitor to the country? I mean, it's like this guy has been the pillar of loyalty and honor and duty for his entire life, his kid's life, his family, his brother, even does it. So it doesn't make any sense. But of course, because it's political, everybody wants to identify with a side. Because he was working with Trump, now he's bad, he's tainted, and now he's Trump's problem. So we're going to go wipe out Trump, and General Michael Flynn has everything to do with the problems that we see. Okay, so that's who this guy is. Now let's break down what happened, because this is where it gets messy. And now forgive me if some of this is wrong or if I'm making a mistake on some of this stuff, but it is complicated. There's a lot of information scattered all over the place. A lot of people got this thing wrong, really, really wrong. So like for the first 2 years of this, even Trump was throwing Michael Flynn under the bus to a certain extent. He said he lied. There's videos of him on, he lied and he said this and he said that and he's a traitor, and all these types of language was being thrown around because it looked pretty bad for Michael Flynn. Fortunately, a lot has developed through that time. So my point is that all these people on all different sides of the political spectrum were very angry about this, and many people thought that they had it all figured out and they had all the answers, and they really didn't. So let me give you my sort of breakdown, my analysis on what I think this looks like. And this is going to look really complicated. Brace yourself. All right. So here is the timeline on the Michael Flynn case. Now let's start on the left side here. On Election Day, okay, so you remember, right around November, we have an election. It's on November 3rd. We take it back to 2016, 4 years ago. Donald Trump versus Hillary Clinton on Election Day. Obama's in office. Biden is vice president. So we start the election on November 3rd. A couple days after that, Obama issues some sanctions against the Russians. You remember that? So this actually not a couple days. This is a couple months later, a month later. Obama issues sanctions against Russia for interference, the Russian collusion. They bought some Facebook ads, this whole thing. He issues some sanctions. On the same day, General Flynn is speaking with a Russian ambassador named Kislyak. So Michael Flynn, who is now going to be a part of Trump's transition team. So he's going to help him get into office, and he's going to become his national security advisor. Trump wins the election, and then his national security advisor calls the Russians. Now, the nature of the calls, now remember, Trump has not taken office yet. So Obama is still in office. Trump is going to be taking office. He's the president-elect, but he's not the president yet. So Obama sanctions the Russians on December 29th. Flynn gets on the phone with the Russian ambassador, Kislyak. And you can see that here. They have a couple calls. Flynn and Kislyak speak on December 29th, and then Kislyak calls back 2 days later, on December 31st. Okay, so what the heck are these guys talking about? Well, Flynn is telling the Russian ambassador, hey, we know that Obama just passed these sanctions. Don't respond. Don't react. Don't do anything about those things. Okay, don't tell Putin, tell your people over there not to counter. Don't hit us back with sanctions. Don't press the nuclear button just yet. Okay, Trump is coming. Trump's on the way. He's going to be here in about a month. So just hang tight. Actually, less than that. He's going to be here in less than a month. So Flynn calls Kislyak, or Kislyak calls Flynn. I don't know who initiated the call, but they're talking because there's a transition taking place. Trump's team is going to be supplanting Obama's team, and all Flynn is trying to do is keep the relationship from souring, even though Obama just issued sanctions on the Russians. They decide, they're going to talk, and I don't know what the conclusion was. Doesn't really matter. The fact that Flynn is talking to the Russian ambassador, that's the subject of this whole thing. Everything else that you see here, it's all stemming from this one call. It's all stemming from Flynn saying, hey, we know that Hillary just lost. Trump won. Obama passed some sanctions against you. Hang tight. We think this is all nonsense. We're going to be in office in a month. Just don't respond. Let us get into power before you do anything, because if you do something now, it's going to jeopardize our working relationship for the rest of the administration. And I mean, to me, it sounds like a pretty reasonable call to be making, right? You're in a period of transition. There is a changing of the guard. You're going to have to hand over power one way or the other. So this is the subject of the phone call. Now, about a month later, Trump takes office in January 20th, 2017. Flynn, now remember, that entire time, Obama is still in power. So Obama still has control of the Department of Justice. Obama still has control of the Attorney General. He's still meeting with his cabinet. He's still got Biden in the office. He's got James Comey in the Oval Office. And so a lot of stuff is taking place, behind the scenes before Trump ever takes office. So Trump now then takes office January 20th. FBI talks to Flynn on January 24th. So they come in just a few days after the Trump administration moves into the White House. They take power on January 20th and in 2017, and Flynn is now talking to the FBI. Now, if you've listened to James Comey, if you've been following this news at all, James Comey had said that they kind of broke their protocols for communicating with somebody from the White House because they knew that the Trump administration had just gotten in there. They were just setting up, and they really didn't know what the protocols were. So Comey said, no, we just sent somebody right over there. We just basically knocked on their door and said, hey, we want to have a friendly chat and let's talk about this stuff. So that's what they did. They have this conversation, and something happens. They start making these notes. Flynn goes on and he resigns in February 13, 2017. So he was not part of the administration for long, just under a month. He resigns. And then Robert Mueller, you all remember Robert Mueller, of course, he gets appointed shortly thereafter. So he's appointed in May 17, 2017. Now, again, a lot of this stuff is all holdovers from the Obama administration. So we're in May. We're just 4 months into the Trump administration. Flynn has already resigned. He's talked to the FBI. He's done all of this stuff, and these are all Obama appointees. Trump hasn't appointed any of these people yet, so they're all holdovers from the Obama administration. Now, Robert Mueller gets appointed on May 17th. The investigation continues. This chart is not to scale. Okay, there's a lot of time that happens between this dot and this dot. Let's fast forward to December. General Flynn pleads guilty, and then Flynn is actually cooperating with the FBI from basically this entire time. So from about December 1st all through May 17th, 2017, all the way up until December 4th, 2018, Flynn is cooperating with the government, and he pleads guilty. And then a bunch of stuff starts leaking out. The Mueller report comes out. It basically says that, there's not much there. It's kind of a big nothing burger. The Democratic Party and Flynn have been investigating this stuff for a couple years. Mueller report comes out. It's a big nothing burger. Nothing really changes at all, but more stuff is coming to light because now the administration is investigating what was the basis of the underlying investigation. Now they're looking into, well, who were these FBI agents who were investigating Flynn? And how did they get his phone call? How did they know that he spoke to the Russian ambassador? All that stuff is supposed to be privileged, right? It's a matter of national security. Well, the U.S. government has wiretaps that they can just capture all of your phone calls. If you're communicating with a foreign adversary or a foreign power, your calls are subject to being wiretapped. They can just swoop up those calls. And so what they do is they mask the people who shouldn't have been scooped up in the calls. So you can scoop up anybody. If you're talking to the Russian president, you can spy on the Russian president. He's not an American. He's not subject to our constitutional rules. He's not subject to having his communications protected by the Fourth Amendment, the laws against unreasonable searches and seizures and those things. So you can listen to all of those foreign calls all day, all you want. But when that conversation involves a U.S. citizen, now you got to protect that citizen. We got to protect that person's rights. So they do what's called masking, meaning they take that person's information back out of the data, then they turn that data over to somebody. So in this situation, what it would have looked like is, well, somebody was talking to the Russian ambassador Kislyak. Somebody was. We don't know who, because that other person was masked. Well, now we go through an unmasking process. So you see how this gets complicated. So then they have an unmasking process where members of the administration, and in particular the Obama administration, because all this stuff was happening while it was on their watch, they're doing all of these unmasking procedures. They all know it's General Flynn because it's really easy to go get somebody unmasked. And now they are starting to, the theory is they're starting to calculate, how are we going to set this guy up? And this goes on. There's a lot to this that I'm not going to get into on this channel or on this particular episode. We may dive further into the story if there's a demand for it. But by and large, there's a lot of malfeasance going on. Flynn, the Mueller report gets released. General Flynn changes lawyers, and then they get new information about these unmasking requests. We have more FBI documents that are unsealed, and then Flynn actually withdraws his guilty plea. So this is important. A lot of people have been one of the main criticisms of General Flynn has been that, Well, he pled guilty, so obviously he's guilty, and he knew what he was doing. And he's, if he said I'm guilty in court, that must mean he's guilty. And any attempt to withdraw a guilty plea, it must be, false, or he must be lying about this, or there's something wrong with this guy. He pled guilty. He knew, he admitted he did it, because people think that people don't plead guilty, but I can tell you, people plead guilty all the time, even when they're not guilty. People plead guilty all the time when they're innocent, is the better way to say it. This happens all the time. It happens every day. People are pleading guilty to charges that they didn't actually do. This happens sometimes with their full knowledge. They know, like say, for example, if you get charged with a DUI and you want to reduce your DUI from a high-level offense to a low-level offense like reckless driving, well, you really didn't do reckless driving. You really did a DUI, but you're going to be pleading guilty to reckless driving because it's a lower-level offense. So it doesn't really apply to you, but you're going to plead guilty to that charge. And courts allow that to happen. Prosecutors allow that to happen. It happens every single day in our criminal justice system. People plead guilty for things that they didn't do. People also plead guilty because of coercion. They plead guilty all of the time because if they don't plead guilty, the penalties that they face as a result of our mandatory sentencing laws, which are very stupid, they can be sentenced for an eternity in prison. So if a prosecutor comes to you and you did a crime that you didn't do, let's take you specifically, I'm talking to you. Let's say that you're sitting there in a prosecutor's office. They're charging you with possession of drugs, something minor, right? Possession of Xanax, you don't have a prescription, and they come into you and they say, listen, we know that you did this. You go, I didn't do it. Like, we know you did it. Here, but because it's your first offense, because it's not a big deal, we're going to give you probation on this case, meaning as long as you're cooperative and you tell us where you got it and you do all of these things, we're gonna put you on probation. As long as you don't break the law, then you're not going to go to jail. All you have to do is just admit here that you plead guilty to that charge. We're just going to let you go. Okay, but I didn't do it, so I'm not going to sign that document. Okay, well, that's fine. That's your choice. You don't have to sign the document, of course. But just so you know that if you don't sign this document, that the mandatory penalty, according to our sentencing laws in our state, it means that if you go to trial and lose, you go to jail for 10 years. You go to prison, actually. It's prison for 10 years. So I've got this probation deal right here for you. Or you can reject it. That's fine. And we can just take your case to trial. And if you lose, we're going to be seeking the maximum. Actually, we're going to seek the aggravated term because of all the work you're going to put us through. And we're going to want 12 years in prison. So, of course, anybody in that position just goes, and they're right, by the way, a lot of the times. Now, this is just an example. The laws are, the laws are different. They depend on all sorts of things. But it's an example. They have a big threat that they hang over your head and they say, take this guilty plea. Otherwise, you are going to go to prison for a long time. And so everybody, of course, just goes, sure, give me the document. I'll sign it, no problem. And they do it all the time. They sign documents all the time. They plead guilty just to make the case go away because it's very expensive to go to court. It's very expensive to hire lawyers. It's very expensive to sit there all day and go through these proceedings. And it's just, it's a lot. And many people just don't want to do it. So if they have an easy way out, they're going to take the path of least resistance and they're going to sign a plea agreement, even though they didn't commit the crime, even though they are not guilty of that underlying offense. Happens all the time. And the final way that this stuff happens is when somebody's just in custody. This was not Michael Flynn's case, but this happens all the time. Somebody will get arrested for a charge. They'll go into jail. They'll spend the night in jail. The prosecutor will see them the next morning and they'll say, listen, if you plead guilty to this offense, I'll let you out of custody. I'll just let you out. Just go home. Just sign here. We'll go in front of the judge. We'll close this case out. You're done. You go home. And they say, well, what if I don't sign that? Well, then I'm going to be asking for a bond because we're going to have to go through the court process and I can't be sure that you're going to come back. So I'm going to ask for $5,000 bond. And it's a real simple process. All you got to do is post your bond. Just take $5,000 and just throw it down with the court. They'll hold on to it for the next few months in case you need it. Just, you don't get to use it. They're going to hang on to that just to make sure you come to court and all those things. Then we'll let you out of jail. Okay, well, what about my charges? Oh, I'm still going to charge you. Yeah, we're gonna come back. We're gonna have multiple court dates, and yeah, at the end of it, I'm going to be asking for more jail time, and I'm also going to be opposing any dismissal request or any deviation request, and so those are your options. So again, people just go, all right, give me the document, and they just sign it. So people plead guilty all the time. It happens every day, every day, every day. Some of it's good. Some of it, we want that. We want those reductions. But some of it's not good. Some of it's very bad. So just the fact that Michael Flynn actually pled guilty really doesn't mean much of anything. People want to hang their hat on it. Doesn't mean much of anything. My understanding is there were some threats being made against his son, and they were threatening him, with all these additional repercussions, and he didn't have, Trump didn't have his back anymore. And so this guy is under a ton of pressure. So he pleads guilty. Then he actually changes lawyers. So from June 6th to June 12th, he changes lawyers. He gets a much better lawyer on his team. Sidney Powell has been running with this ever since all this stuff started happening. And then they file a motion to dismiss the case. They say new evidence has come out. It's exculpatory evidence. And there's been kind of a landslide of this stuff coming down the pike. And I think there's even more coming. If you believe Attorney General Barr, if you believe the Durham investigation, if you believe some of the guys who've been screaming about this stuff for years, like Dan Bongino and some of these other people, Trump himself is saying on his Twitter feed that there is more coming. There's the malfeasance here it's even greater than what you're expecting. And what happened is we got all sorts of information about the FBI really didn't have the authority to continue this investigation. They had it all justified on a false pretext, meaning they had no basis for listening in on those calls and really spending time investigating General Flynn. What they were charging him with, what the underlying crime that they were charging him with, is what we call a process crime. All right, and this is something I want to talk about. I want to spend a little time on this. Process crimes. So let's say, for example, you're alleged to have robbed a bank. I talk about the bank robbery analogy on the show because it just works so well in so many different areas. But let's say you're under investigation for robbing a bank, right? There's 4 people who go and rob a bank. There's a getaway driver and the 3 other guys. They go in, rob the bank. They come back out. They take off. All right, so you're under investigation for the bank robbery, right? And they go in and they say, okay, hey, no problem. We're under investigation for the bank robbery crime. We really want to find out who robbed this bank. A lot of money was taken. A lot of people were scared, and we need to get to the bottom of this. Great. Okay. Did you rob the bank? No, didn't rob the bank. Okay. Were you anywhere in the area around that time? Nope. Wasn't anywhere in the area, and don't know anything about it. Okay. All right. So you weren't anywhere near the bank at all? No, not at all. You weren't in the cross streets of Scottsdale Road and Shea? No, wasn't anywhere near there. Okay. And so you're certain that you weren't even in the zip code? No, man, I wasn't in the zip code. I wasn't in the state. I don't know anything about the bank robbery. Leave me alone. Oh, okay. So you weren't in the state. Okay, sounds good. All right, well, and okay, so no more questions. Thank you. Thanks for having this conversation with us. We appreciate it. Obviously, you had nothing to do with this, and you're out. You're free to go. Okay. So that's essentially the end of their investigation, right? Well, no, wrong, because what they're doing is they're going to charge you with a process crime. They're going to say, you were under oath and having a conversation with us. You told us you never left the state, and you've never been to Scottsdale and Shea, and you never even seen that bank before, but we have all this evidence that you did. You did see the bank. You were in Arizona on that day, and you've been to this branch before, by the way. We don't have any evidence that you robbed it, but you have a checking account there. Okay, so all of those lies are called process crimes because they have nothing to do with the underlying bank robbery. There's no information about that, whether you did rob the bank or not. It's not there. There's no evidence of that. They're going to charge you with a crime like perjury for lying to them under oath of a formal investigation that's surrounding national security in General Flynn's case. So they didn't actually charge him with colluding with Russia, but they charged him for sort of lying about these conversations or misremembering or not being as honest as he could have been about some of those other conversations, not about the underlying fact. They weren't concerned about the bank robbery itself. They were concerned about the conversation that they had while they were investigating the bank robbery. There's a pretty big difference there. It's called a process crime. It's called a perjury trap. You get somebody talking and then they hang themselves. They admit something that is maybe less than true or not as true, or they're misremembering something. This is why it's so important to not talk to the police. You can't talk to them. This applies to General Flynn. It applies to me. It applies to you. You don't talk to these people because they can spin you in circles and they can charge you with the crime for the information that you give them during their investigation into another crime. So you see how messed up this is? This is what they do. And that's what happened in General Flynn's case. Now, what ended up happening is once a lot of these, this new material, these FBI documents started to get unsealed, we started to learn that there's more to the story. There's more, the basis for the investigation seems like it was manufactured a lot more than it was warranted. We have notes from a lot of these people. We have Lisa Page, we've got Peter Strzok, we've got Christopher Steele, we've got James Comey, we've got Carter Page, we've got Sidney Powell, who is representing Michael Flynn, we've got Eric Holder, we've got Sally Yates. Now we've got even evidence that Joe Biden and Barack Obama were having a conversation about this case in the Oval Office and sort of guiding the investigation even as they were leaving office. So basically one president is sort of setting the framework to prosecute another president prior to him leaving office during a transition of power over a manufactured phone call or an allegation about a phone call, which was allegedly collusion, which to me doesn't sound anything at all like collusion other than it's part of the transition team having a natural conversation that they need to have. So this entire investigation comes to fruition and the FBI documents start to get unsealed. We have a lot of changing of the guards. The Trump administration ejects a bunch of people from the Obama era. They bring in new people and these documents get unsealed. And the Department of Justice then turns around and says, you know what? We're actually going to drop the charges. So May 7th happens and we're going to dismiss everything. We're just going to dump this case because we don't think we can prove it anymore. We don't think that beyond a reasonable doubt that we can prove that Michael Flynn did collude or that he did commit any of the crimes that were alleged. They don't even think that the investigation should have happened. It seems like it was a political investigation rather than a legitimate investigation. I just told you about General Michael Flynn and all of his accolades and all of his background. Turns out that he's more in alignment with those credentials than any of the other allegations. So these docs get unsealed. The Department of Justice turns around. They go to the court and they say, listen, we know we've been prosecuting this case for a long time, but we don't think we have the evidence anymore for it. And we're going to turn around and we're going to dismiss the case. Should be the end of it. Okay. Remember back to your constitutional law class or your civics class or your social studies class. Remember what we're talking about. We're talking about three co-equal branches of government in the United States. You've got the executive, you've got the judicial branch, and you've got the legislative branch. We got three co-equal branches of government. Same type of thing happens in criminal law. We have three parties, right? We've got the judge. We've got the defendant, who's the defense. In this case, it was Michael Flynn. We've got the prosecutors, right? And they're all supposed to have there's supposed to be three co-equal branches of government or three co-equal branches. The defendants have a certain number of rights. The prosecutor has a certain number of rights and the judge has a certain number of rights. And these things are all supposed to operate without kind of getting meshed into one another, right? If the prosecutor's office and the judge's office are colluding and conspiring with one another, it's really hard for the defendant to do anything. So the judge is supposed to be the neutral arbiter. The prosecutor is supposed to be the one who brings the charges, and the defense is the one who defends against those charges. So in Michael Flynn's case, yeah, they file a motion to dismiss. They want this case gone. The defendant wants his case gone. The prosecutor's office comes back and says, yeah, you know what? After a lot of investigation, we also want the case gone. We think it's nonsense. We don't think there's any basis for continued prosecution. So we've got two people agreeing in this courtroom saying this case has got to go. But what happens? The judge, who ordinarily in any other criminal case I've ever been a part of or our firm has been a part of, if the defense files a motion to dismiss or the government files a motion to dismiss and they're in agreement, if these two people are in agreement about what should happen in a case, the judge just basically says, sure, yep, you got it. Because that's what the judge is supposed to do. They're neutral. They're not supposed to take a side, especially when they're in agreement. If there's a disagreement, then the judge goes in and they ask questions and they hold hearings and they get to the bottom of it, right? And then the judge issues a ruling. So if you say, the defense says I want it dismissed, the prosecution says, no, we want it to stay, then we have arguments over that. But in Flynn's case, we had both sides who said, this case is nonsense. We want to dismiss all of these charges. And the judge said no. The judge said, nope, we are not going to do that. Which, in my mind, it was raising red flags all across the legal community, because everybody was scratching their head going, what? What's his basis for doing that? What's his authority to not dismiss the case? So now what we're seeing is the judge was sort of acting almost as another prosecutor. The judge was saying, Mr. DOJ, Department of Justice, Mr. Government, we don't think that you are being forthcoming in your dismissal, and we're not going to let you dismiss the case. So we're going to act almost as the prosecutor, and we're going to say no dismissal, even though the defense and the prosecution were in total agreement for the dismissal of the charge. So, yeah, so it caused a lot of murkiness. It caused a lot of what is going on? How is this even happening? Because it shouldn't, because that's not how the system works. Well, what ended up happening is Flynn got the new lawyers, and they filed new motions. They wanted what's called a writ of mandamus, and let's pull this up. I want to run you through what this order looks like. So a writ of mandamus it's a legal proceeding where it's a legal request where basically they're asking an appeals court to order the lower court to do something. So in this case, in Michael Flynn's case, the lower court judge decided he was not going to dismiss the case. So I'm not going to dismiss it. We're going to hold hearings. We're going to do a bunch of stuff about it. And Michael Flynn's attorney said, okay, that's fine. You're the district court. We're going to go up above you to the appeals court, which is the DC Circuit Court, which is the federal appeals court for the DC Circuit Court of Appeals. And we're going to ask them to order you to dismiss it. And so what happened? Well, we got the order today. The Court of Appeals actually listened to all the arguments. They put together a 38-page opinion and order, which I read almost all of it today. I didn't touch the dissent, which is the disagreement part. So when you get an opinion and an order from a court, you have the majority opinion, which is going to be the rule, and it's going to be the law, and it's going to be the precedent. And then you have the dissent, which is the judges who disagree. So let's go through the order. It just came out literally today on June 24th, 2020, and here's what it looks like. The United States Court of Appeals for the U.S. District Court Circuit, Columbia Circuit. And when you start going through this order, you're going to see kind of a lot of really fluffy, a lot of language. A lot of this is legal stuff, right? So they're saying that Team Flynn. So these are, I was kind of dissecting the parties. We were talking about, who is on whose side. And so we've got petitioners, we've got all these different attorney generals for the state of Alaska, Arkansas, Florida, Georgia, Louisiana, blah, blah, blah. They're all supporting Michael Flynn and so on and so forth. So we just keep going. Everybody's in support of this until we finally get to the opinion, which was filed by Circuit Judge Rao. All right. So here we go. So this is sort of the timeline of how all this happened. So if you quick recall, what the court will do is they're going to go through what's called the procedural posture. Basically, they're going to say all of this stuff happened. He pled guilty. He withdrew from the plea. The government filed a motion to dismiss. The judge does not grant the motion to dismiss. They appointed what's called an amicus. Okay, so an amicus is a Latin word. It basically means friend, or in legal parlance, it's called friend of the court. And what this judge did, Judge Sullivan, is he said that, no, we're not going to dismiss the charges. What I'm actually going to do is appoint somebody else. An amicus, it's a friend of the court. It's somebody with expertise or wisdom, or the court wants opinions from somebody from the outside of the case, because they're not involved in the case. So it's like, okay, we're all too muddled in this. Our heads are in the weeds. We need somebody from the outside to come in and tell us how we should handle this case. And so they brought this gentleman in. We're going to talk about who he is, to argue against or to basically act as a third party. He ends up arguing against terminating the prosecution against Michael Flynn. So then when the judge did this, so Judge Sullivan says, not going to dismiss the charges. I'm going to bring in and appoint this third party person to come in and give us his opinion. And we're also going to set a hearing so we can discuss these things. The government wants the case dismissed. Michael Flynn wants the case dismissed, but I don't really want to do anything about that. So I'm going to bring in this third-party person, and we're all going to talk about it, and we're going to do it in July. So then Flynn's attorney comes back and says, no, we're not. That's not going to happen. We're going to file for this writ of mandamus, which you can see here under the 28 U.S.C. 1651, and they're going to ask for these three things. One, an order directing the court to dismiss the case. Number two, they want to vacate the hearing about that, and then they want to get a new judge. So those are the three things that they want, and they get the big one, but we'll save that until we get there. So they go through, and the opinion talks a lot about whether or not they should be granting what's called a writ of mandamus. And so the mandamus process it's a lot, right? It's a superior court talking to an inferior court and ordering them to do something, which is a big deal, right? You don't want that to happen. You want due process in normal courts. You want the courts to resolve things on their own. You don't want, basically you don't want the superior court or the appeals court or the Supreme Court acting almost as like, filling in for those lower level courts, sort of supplanting them in a certain way. You don't want that to happen. So you want to let them go through their own process, go through due process, and come to their own conclusions. But when they can't do that, then a writ of mandamus becomes appropriate. And so that's what they're asking for here. They're saying, we want you to order them to do something. And so the majority opinion comes through and they say that we understand that the right to relief must be clear and indisputable. There must be no other adequate means to attain relief. So they're saying the mandamus has to be the last resort. Like we are only going to do this if there's no other ways for us to solve this issue. They go forward, and they're really talking about this guy here. So this is Judge Emmett Sullivan, and he talks about the basis for what he's calling leave of the court. So now he's going to sink his teeth into an argument. He's going to say, the reason I did this is because according to Rule 48, I can take leave. I can take leave of court, and I can go make a determination on my own. I can say whether or not I want to grant this motion to dismiss, whether I can or not. And so he's saying, I have full authority under this rule, and he goes through it, and he talks about some of this case law and how it all works. But the court comes back and they say, when the government moves to the principal object of the leave of the court requirement is to protect the defendant against prosecutorial harassment when the government moves to dismiss an indictment over the defendant's objection. That's a fancy way of saying, I didn't show you the screen there. This is a fancy way of saying that if, let's say, for example, that Michael Flynn wanted to dismiss his case or I'm sorry, let's reverse that. Let's say the government wanted to dismiss the case and Michael Flynn objected to the dismissal. There are reasons for that. Then this is the appropriate time for the government to step back in. But because in this case, the government and Michael Flynn are in agreement, this is not appropriate. The leave of absence is not appropriate. They go through, they talk about that there was, Flynn agrees with the government motion to dismiss. There was newly discovered evidence. The Department of Justice, and specifically the government, points to evidence from the FBI, which, where the false statements were allegedly made. They say that the interview was untethered to and unjustified by the FBI's counterintelligence investigation into Michael Flynn. The government says it cannot prove the relevant false statements or their materiality beyond a reasonable doubt. Insufficient evidence is a quintessential justification for dismissing charges. And that's 100% right. So if the government comes back and says, well, we don't have enough evidence, we looked into this thing further and we think that this whole underlying prosecution was corrupt and illegitimate from the beginning, we're not going to continue to prosecute the case. We're not going to do that. We want that to happen. We want prosecutors to have the authority and the discretion to stop prosecuting bad cases. If they see that the evidence doesn't fit, they want to, we want to give them the authority and the wherewithal to terminate that. We don't want people to continue to prosecute cases that shouldn't be prosecuted. So the counter argument to that, right, the response back is, yeah, but this is political, though. General Flynn, his case is only getting dismissed now because there's been a changing of the guard. Comey's no longer at the FBI. All of the Obama era appointees are all gone. They've all been replaced. We've had a number of different attorney generals since then. The Department of Justice has had some maneuvers and stuff. And so the critics are saying, wait a minute, now this dismissal cannot be allowed because it's political. The political system has changed, and therefore this thing is it's corrupt. They shouldn't be dismissing this case. It's only being dismissed because Trump put his people in. But Obama had his people in, right? So this all started under Obama's people, and it's ending under Trump's people. So, you know, the criticism cuts both ways. If you're going to say it's political, then if you're going to say that the dismissal from the Department of Justice is political, then you also have to acknowledge that maybe the prosecution of General Flynn at the beginning was also political. You can't have it both ways. So it's either political or it wasn't. Well, the court recognizes this. The court knows that that's true, and that is a justifiable criticism. So how does it deal with that? Well, it talks about what they call the presumption of regularity, right? So as opposed to political, the government's representations about the insufficiency of the evidence are entitled to a presumption of regularity. So what this is saying is that if the government comes back and says, we don't have the evidence to move forward on this thing, the court is going to just presume that that is the truth. They're going to presume that that is the regular function of the government, that that's the basis. That's the starting point. We're going to say that we're going to believe them. The presumption starts, we're going to believe the government. The court goes on to say, this carries on, presumption of regularity in the absence of clear evidence to the contrary. So they are saying that if we see some evidence of irregularity, if we see some political bias, if we see some of that stuff, then yeah, they don't get the presumption anymore. But it goes on to say, we don't see any of that here. So here's what we've got. There is no clear evidence in this case on the record before the district court. There is no clear evidence contrary to the government's representations that they were operating with regularity. There's no evidence on the record. The justifications that the district court offers in support of further inquiry, for instance, that only the U.S. attorney signed the motion without any line prosecutors, that the motion is longer than most Rule 48 motions, they are all insufficient to rebut the presumption of regularity to which the government is entitled. So the judge in the district court did say, he had some basis for it. He said, well, the motion was a little longer than some of the other motions, or it was long, or maybe it broke the rules, it was too long, or maybe it was, the signature was only from the U.S. attorney, but it didn't have any other prosecutors on there, so maybe this wasn't an office decision. Maybe this was a single prosecutor's decision, which means that maybe that's a little bit irregular. But by and large, those are small potatoes, right? Those are just kind of minor procedural things that are happening. One's a motion's too long, and one didn't have, everybody's signature on it. Is that a basis to presume that the government was operating out of normalcy? They were operating with irregularity, that this whole thing was political and unjustified? No, the court goes on and says, we don't have any evidence about that. We don't have any evidence that any of that stuff exists. And they actually go through and they are discussing Judge Sullivan's rationale for needing the leave. So remember, Judge Sullivan was the one who said, we need more time. We need to investigate this. We need to appoint the amicus, that third-party provider person, and we also need to have a hearing, and we're going to call all these people into court, and we're going to get to the bottom of this thing. And so in his response, so when Flynn's attorneys filed the writ of mandamus, Sullivan gets the opportunity to respond. The judge gets to respond and say, no, this is why I did it. And he did, and he said, here was why he wanted to have this hearing. He wanted to question the bona fides of the government's motion. He wanted to inquire about the government's motions and their representations. He wanted to illuminate the full circumstances surrounding the proposed dismissal. And he wanted to probe whether the presumption of regularity for prosecutorial decisions is overcome in the unusual facts of this case. So he's really wanting to dive in. He wants to open up the government's files and look through them and look through the notes. And he wants to, ask everybody, well, what about this and what about that? And basically, he wants to sort of act as a prosecutor in the case. He wants to vet what the prosecutor's decisions are. But that's not his job. He's the judge. He is not the prosecutor. The prosecutor is the one who gets to make that decision. And they did. And there's no evidence on the record that they didn't do a good job of that. There's nothing that we have seen on the record that shows that this was political or that there was no basis for it. In fact, the opposite is actually true. We're getting more documents on a daily basis showing that they were fibbing this thing all over the place. And the judge doesn't want to accept that. Instead, he wants to call everybody back into his courtroom, and he wants to sort of take control of the prosecution. And the court says, you can't do that, man. That's not your job. You're not allowed to do that. He says a hearing may be appropriate in some situations, but a hearing cannot be used as an occasion to superintend the prosecution's charging decision, because authority over criminal charging decisions resides fundamentally with the executive, without the involvement of and without the oversight of power in the judiciary, which is exactly right. This is a balance of power thing that I was talking about. This is the separation that we need in order for all this stuff to function. If you have the judge who is acting as a prosecutor, then what do you need the prosecutor for? And if they're commingled to a certain extent, the defense is now outnumbered. The government itself is saying, we don't want to prosecute this guy, but now he's got to go back and he's got to fight the judge and the prosecutor and other people who were involved in the case, like the amicus. So it's not good. It's not a good way to practice law. And the opinion, I think, gets it exactly right. It says the proposed hearing constitutes clear legal error, and it just continues to move on. Now, a big part of this opinion is actually justifying the use of the mandamus. The mandamus is, again, it's the superior court coming back and telling the lower court, you have to do something a certain way. And the court spends time on clearing this stuff out. They go through it, see all of this here. It's all case law. It's all, precedent from different jurisdictions, from the Supreme Court, from the DC Circuit, and so on, 1998, 2003. So it's all just case law, sort of fleshing out the rules on when a mandamus is appropriate and when it's not appropriate. And so they go on, they reiterate a few things, that the government cannot pry into the government's decision-making power by, if Judge Sullivan got his way, in other words, and everybody was in the government's files and asking the government about everything that they decided to do, it would reveal the internal deliberative process. And it's basically done with the intent to scrutinize the reasoning and the motives of the Department of Justice. And by getting in there and by meddling in that process, you're causing irreparable harm that cannot be remedied. And that's what this opinion says right here. Irreparable harm that cannot be remedied on appeal. And they must step in to prevent the judicial usurpation of executive power. Right? They need to get in, they need to get involved so that this doesn't continue to go on. Because if Judge Sullivan got his way and General Flynn had to go and appear in front of this amicus and all of this stuff, now he's contending against the prosecutor's office and the judge, and he's outnumbered. There's a commingling, there's an improper balance of power in that effect. So that was, I think, a great point. Exactly on point. This was sort of my initial thought when this judge refused to dismiss the case. When the prosecutors and the Department of Justice said that they were going to dismiss the case, I thought that was the end of this for sure. And I was a little surprised that it kept going on and on and on. The court goes on. It talks about this amicus, John Gleason. So that's this guy right here. This was the guy that Judge Sullivan brought in to argue as the amicus. This is the friend of the court type of individual. And the court goes on to point out that the government, if they bring this guy in, it was done so that he could present arguments in opposition to the government's motion. So basically what they're saying is that they brought this guy in to act as a prosecutor. If the Department of Justice is not going to prosecute Flynn, Judge Sullivan comes back out and says, that's fine. I'm going to appoint my own guy, John Gleason, who's going to be the actual prosecutor of the case. He's going to come in and he's going to argue that the government should not have moved to dismiss the case. They should continue to prosecute him. Well, the court says that all of this stuff doesn't matter what happens under Rule 48 and the leave of absence and all that stuff. The rule does not include designating an advocate to defend Flynn's continued prosecution. The district court's order put two co-equal branches of government on a collision course, and that's exactly right. That's exactly what he did. The judge was asking somebody else to come in and tell the prosecutor's office why they needed to continue to prosecute. That's not the judge's job. It's not at all their job. They should be making sure that things are operating, appropriately. But when two sides are in alignment, for the court to go ahead and just dismiss that doesn't make any sense at all to me. Let's keep going through the opinion. So this is the Gleason brief. So Gleason files his own brief. He files the amicus brief, and he says that the government, they used a lot of stuff as a pretext to dismiss the case. Basically, he's making the argument that it's prosecutorial abuse and that it is essentially political in a lot of ways. He relied on news stories, tweets, and facts outside the record to contrast the government's grounds for dismissal, which is funny because when I saw his brief come through, I did see some other defense attorneys who were like, yeah, what a great brief. And I was thinking, what? None of this stuff is part of the record, but even defense attorneys can get political. They can see this stuff. I get political too, believe it or not. But okay, so let's go back to the opinion. It says that the court should be neutral, and it necessarily doesn't get to weigh the merits of the case. So Gleason encouraged the district court to scrutinize the government's view of the strength of its case. So Gleason is telling the Department of Justice, you don't think your case is strong, but we want the judge to go in and verify that your case is strong. And you just can't do that. Again, it's a co-equal branches of government. It's not the judge's job to go in and tell the prosecutor how to do their job. It would be as absurd as a prosecutor going to the judge and telling the judge to do what the prosecutor thinks that they should do, or the defense telling the prosecutor what they should do, or the judge. It's asinine behavior, but this is what came out of this particular case. Now, the Department of Justice is also saying, they quote here, the court quotes here from their manual, as a matter of fundamental fairness and in the interest of efficient administration of justice, no prosecution should be initiated against any person unless the attorney for the government believes the admissible evidence is sufficient to obtain and sustain a guilty verdict by an unbiased trier of fact. And that's their manual. That's something that we want prosecutors to do. We want them to dump bad cases. We wish they did more of that, but unfortunately they do not. Again, they hide behind their policies. The opinion goes on. We'll get through it here pretty quickly. Mandamus justification. So again, the mandamus remedy allows the Court of Appeals to prevent encroachment on a co-equal department, and they're going to do it here. So boom, granted. In part, what they're saying is we're going to grant the mandamus and in part, and we're gonna deny it in part. So if you remember when I talked about this, the Flynn writ for mandamus wanted three things. It wanted the appeals court, to order the lower court to dismiss the case. So it's not, the appeals court is not dismissing it. It's passing it back down to the district court, and it's saying the district court has to dismiss the case. It's ordering them to do something, but it's not the appeals court dismissing itself. That was number one. Number two is to get rid of the hearing for the amicus hearing. So it's saying, that John Gleason guy and that hearing that Judge Sullivan set, we don't want that happening anymore either. And then the third part that Flynn's attorney asked for was for a change of judge. Basically, they said Judge Sullivan is too biased, too political, doesn't know what he's doing, and we want a different judge. So those are the three things that they asked for, and the appeals court didn't give them all of them. It split them. So on the first one, here's what they did. They said, we grant the petition for mandamus in part and order the district court to grant the government's Rule 48 motion to dismiss the charges against Flynn. So that's the first one. Granted, boom, that's the big one. The appeals court is going to be ordering the district court to take the case and dismiss it. Now, when the case gets dismissed, what does that mean? Means that we don't have an amicus anymore. We don't have an amicus hearing. We don't have John Gleason coming in. We don't have any of that stuff happening anymore. So that point is going to be moot. So as to point number two, that's going to be moot. But point number three, we want a different judge. Well, the court says no. The court says no. They say we deny Flynn's petition to the extent that he seeks reassignment of the district judge. No new judge is coming for you. But they are telling Judge Sullivan, the guy who kind of started all this, Judge Sullivan, you are now ordered to dismiss the case. So kind of like a little bit of a backhand, right? You started this whole thing. We're not going to kick you off the case. We're going to send the case right back to your court, and you're going to be the one who has to dismiss all of the charges against General Flynn. So that stings a little bit, right? It's his court. It's his, everybody wanting to see, he's basically turned this entire case into a circus, and now he has to resolve it on his own. So that was the opinion. Let me show you just the rest of it. Now, I did not read a lot of the rest of it. So this is where the opinion basically ends. They say here that they're going to respond to the dissent. So you can see, if you look at my cursor, this is we're on page 12 here. This is the majority opinion. We decline to reassign a new judge, and we grant the government's Rule 48 motion to dismiss. So they're going to dismiss the case. Then they spend a lot of time talking about the dissent. So all of this here is the dissent, a response to the dissent. So this is the final order. And then this is where the dissent starts. So this is where Wilkins, who is another circuit judge, actually dissents. And the crux of his argument is really that Mandamus is not appropriate. He doesn't think it's appropriate at this time. He doesn't get into any of the facts. It's not really a political opinion, really, in either way. But Judge Wilkins is saying that there really is no basis for a Mandamus at this time. He says that he reads the Rule 48 requirement for a leave of absence to consider a motion to dismiss as much broader, and he's saying that really, Judge Sullivan and the district court should have had a little bit more leeway. They should have had these hearings, and they should have had an opportunity to review the record before this would become ripe. So in other words, this is not appropriate for the Court of Appeals to be hearing right now, because there's still work to be done back down on the district court. Now, I think the majority opinion addresses that pretty clearly. They say that there would be sort of irreparable damage that would happen if they didn't act right now. Like if this clown show continued to go on, General Flynn, there's going to be a lot more irreparable harm to everybody involved: the government, Michael Flynn, and the integrity of the court. All of these different things. It's not justified under the case law. So it is something that has been going on for a long time. This opinion just came out today. I really don't even know what this judge is going to do. He may go ahead and grant it and grant the motion to dismiss, and then ride out the rest of his time on the bench. But to me, it kind of feels like he was interested in something else. Like he wanted to make this a little bit of a spectacle. Maybe he rides off into the sunset, writes a book about it, and it becomes a best-selling tell-all before the election, of course, because that's what happens now in our political world. So that was what I had for you on the George Flynn case. It's been very interesting. It's actually been one of the most complicated sort of developments of cases that I've seen over the years, just because of all the people who are involved and all of the back and forth and all of the political consumption. It's been a wild case to follow, but that's what I've got for you on the show today. So let's go ahead and run through some of the comments here. I pull up the comments on YouTube. Let's see what we've got. So Glenn Johnson, given what we know about the George Barnhill, now should George Barnhill be indicted on prosecutorial misconduct? I'm only a first-year law student, but this seems fishy. Yeah. So if I'm not mistaken, George Barnhill was in the Ahmaud Arbery case, and Ahmaud, he was the one who he was I think he was the second prosecutor. So it went to one prosecutor who initially conflicted herself right off the case, and then it passed over to George Barnhill. George Barnhill was the one who wrote that really bizarre letter that said that basically Ahmaud Arbery shot himself 3 times with a shotgun, because he goes through this big asinine paragraph about how it only takes a quarter of an inch to move the trigger, and because he was pulling the gun and Travis McMichael was holding the gun, it fired 3 times and he got shot 3 times, but it was Arbery's fault. That was his basis for it. The ethical rules surrounding prosecutorial misconduct, I don't know what they are. I'm not a prosecutor, have never been a prosecutor, never want to be a prosecutor, and I'm happy about that. But I don't know exactly what their rules are. In my mind, prosecutorial misconduct, anytime that we've ever kind of brought it up, it's typically surrounding a situation where they are overcharging. They're overcharging, or they're being overly aggressive, or they're doing something unethical in the courtroom. Like a good example is if I'm with my client and I'm in the courtroom and we're in there talking, and the prosecutor's in there with her officer talking. They have their case investigator in the courtroom, and maybe I step out to talk to a witness or something, and the prosecutor went and talked to my client. That would be prosecutorial misconduct. That's unethical. She's talking to somebody who's unrepresented. This actually happened in Phoenix. There's a city of Phoenix prosecutor who did that and is in some hot water over that. She's a prosecutor, and I don't know what happened with the case, but it's not okay. You're not allowed to do that. That's misconduct. So how does misconduct work when you are not charging somebody? So that's the big problem with George Barnhill, is that he didn't charge the McMichaels or Roddy. He just sat on it and he just whitewashed it. So is that unethical conduct? I don't know. They have a lot of discretion. I just got done talking about the discretion in Michael Flynn's case, where we're saying that maybe these guys, the Department of Justice has full authority to not charge cases. They're allowed to do that. We give them that power. They're part of the executive branch, and they have a lot of leeway, and courts all over the country go through and give them a lot of deference when it comes to these things. So if George Barnhill decided not to charge it, I think that he's probably justified. I don't think it's going to be prosecutorial misconduct. I think that he probably would have just gotten away with it and just said it was within my discretion, and he probably talked to some other people about it who will back him up. I don't think it's going to go anywhere. I think it should. I think he was covering for a bad popo, but we'll see if anything happens. Great question, though. Thanks, Glenn. Good luck in law school. First year is a tough year, but it's well worth it, especially if you're interested in this stuff. I think you'll have a lot of fun. So just keep grinding through it. I'm sure you've heard it. The first year, they work you to death. The second year, they something you to death. And then the third year, they bore you to death. I think that's how it went. I forget what the second year was. I'm having a mind blank right now. Second year was something. Zulu Zite, lots of comments. But for that video, it would have been like nothing happened. Again, talking about Ahmaud's case. Glenn's back, says, I think it's a shame that a young man had to die for this bill to pass. I agree with that. Monica bless us. Hey, hi, sir. My husband is being charged with assault. If I get a good attorney, you think he will still have to serve time? It's a great question. Yeah, assault, impeding breathing and circulation. So it sounds like it's a felony assault. Anytime you have a case that's an assault charge, so let's say, you get into a fight and you elbow somebody or you punch somebody in the face, as long as there's not really serious injuries, it's probably going to be a lower level misdemeanor assault charge. But as soon as you start wrapping your hands or something around somebody's throat, or you impede their breathing, that really becomes even more dangerous, and that's what elevates it into a felony. So, your husband, depending on his situation, he may, if he's got a lot of prior offenses, he may face a lot of time. If he doesn't have any priors, he may face very little time. A lot of it depends on, the victim, whether they want to be cooperative or not, whether they think this should move forward or not. So there's a lot of things that go into an analysis like that. Now, again, this is only video on our YouTube channel. I am not your lawyer. I don't know anything else about your case. So please do not construe this as legal advice. I don't even know where you're from. So go talk to a lawyer who's licensed in your state. Many criminal defense attorneys offer free case evaluations. I would just go find somebody who's reputable, who's got, some nice, good stars on Google and Yelp, and somebody who maybe has a YouTube channel that you like to communicate with, and see if they'll be a good fit for you. But it's a good question. Let's take a look at some other questions. They need to charge these types of guys if for no other reason than to jack up their background checks for the next series of police departments who would otherwise pick them up. Yeah, that's a great point. I was laughing at the next comment. I too side with Beyonce. She's super hot. Yeah, I was not expecting today. I had no idea that Beyonce was going to be in my slides, and I was surprised. Faith helps me prep for these shows, and of course, she included Beyonce in there. I did not see that story. I missed the story, and to her surprise, I could not even name a Beyonce song off the top of my head. I don't even know one of her songs, but I did Google her. She is pretty good looking woman there. So I've got a lot of comments on that one, but I was very happy that she made the show. Somebody, send her this video and let her know she was on Watching the Watchers. Big deal. But big deal for her. Hopefully she doesn't let it go to her head. Let's go through a couple of other comments. That Zulu Zite says, I love that framed pic. You could probably leave that timeline up for the duration. Okay, thanks. Yeah, I'll post that somewhere. I'll link. I'll link over to that. Good looking honky. Peter North here, friend of Ron. Friend of Ron Jeremy. Are these guys still getting off? You realize this isn't good for American rights. if they, let's see, so if they were forced to prosecute, would it be the same prosecutor or would they have to get a different guy? Never mind, answered. Yeah, so I'm not real sure what question that was referring to, but or what topic that was referring to, but those are the comments, those are the questions, and that's what we've got for you today. I want to, as always, I want to plug the book. Okay, this is my book, it was released this month in June. It's called Beginning to Winning, and it's How to Fight Your Case and Succeed in the Criminal Justice System by yours truly. Look at me right there. Look at that smiling face. What a happy fellow. I just love solving problems. I love helping people. This book is available on Amazon, and it's, I think, $16.99. It's got a lot of information. It's got, all these different, we've got all these different charts in here. We've got some examples. We've got, some bullet points, some things you can start thinking about in your criminal case. We've got all sorts of stuff. I give you a copy of our strategy sheet at the very end, which looks just like this. Our strategy sheet, which, of course, has a lot of information. I mean, basically, sort of the 9 steps that are useful in representing yourself, or even if you have a lawyer, there's attorney accountability tips in here also. So we've got these little boxes that I wrote that looks like this: attorney accountability, how to hold your attorney accountable, because you don't know how this stuff works, and your attorney's telling you one thing, and can you believe him or not? So all this stuff is coming for me. I wrote the whole thing. I'm super proud of it. It's available on Amazon. I'd love it if you picked up a copy if you need it. If you don't need it, you want to support me, I love a 5-star review would be fantastic. That'd be super helpful. And we will be back here next week, same time. The show was really long, but we'll be back here next week at 4 p.m. for a very live, very eventful, lot of fun, Watching the Watchers edition. If you could, do me a favor, hit the subscribe button if you haven't done so already, because that helps remind you that the show's going live. If you got any friends or any family, if you want to submit a link to this video or to this channel, on any one of any of your favorite forums, then that would be amazing for us, because we're just trying to increase awareness. The show's a little bit different, right? It's not as YouTube-y as some other shows. We do some really deep dive and go into some deep materials, which can be a little bit boring for some people, but there are those who are interested and they want to be involved in the conversation. So if you can share it or submit it to some of these forums or anything like that, really would be a huge help for us. And much love. I will see everybody back 1 week from today. Have a wonderful evening. I'll see you on the next one.